અમારા માટે રહેવા દો ને સાહેબ ને એમ કે અમારા માટે રહેવા દો ને એમ કહ્યું.
તો તમે ત્યાં જતા હશો ને?
ના ક્યારે એમને જ કહી દેવા.
તો એ તમે જે બાર સમજી લેજો.
આપને અનુભવ છે
સાહેબ હું 12 વાગે પરમટેરીલી કોર્ટ 1 માં એક મેટર ફિક્સ કરી છે, તો મને આપ સાંભળી લો તો.
કોર્ટ કોલ આઉટ કરી લે પછી.
બપોરે રાખેલી છે.
કયું?
હા સાહેબના સાહેબના
ના 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 11 વાગે કહ્યું તું, હું ત્યાં ચીફ જસ્ટિસ માં ટાઈમ લઈને આવ્યો છું.
અમને તમારી આ કોર્ટ ની ખબર ન્યાનું અમને કઈ ખબર નહીં, તમને ખબર. એમને ખાલી સાંભળવાના છે.
હા
રીમાં કઈક કેવું છે અને આપણે બધા ટાઈમે નહીં આપીએ.
નહીં કઈ
કારણ કે અડધી પોણી કલાક એમને પહોંચતા થશે ટ્રાફિકમાં.
કઈ વાંધો નહીં.
4 નંબર તમે પીઆઈ મારફતે.
સેશન 32/20. હા.
ચાર નંબર સાહેબ સુરત જેલ જય મુદતે આવી હતી કસ્ટડી
સુરત કની હજુ 4 કિલોમીટર છે. પીઆઈ આવે છે ખરાઈ માટે મોકલી દઉં.
ઓનલાઈન
અમારી બપોર પછી રાખીશ.
હા તમારી બપોરે
સેશન 52/20. નંબર 1 ઉપર કેસ અલગ છે. સેશન 30/21. ત્રણે આવેદન મળતી બધી છે. ફરિયાદી આયુ માફી છે.
બાકી
आई क्या है कदाच? हाँ ये 5 मिनट
સેશન 46/1. આરોપી નંબર 1 ને 2 થી ચાલતી ચોરી 3 એવરેજ છે. જેકલિન સર એમાં ક્રોસ કેસ 21 ના છે ડિસિપ્લિન ફરિયાદ અને સારું આવ્યું છે.
આ બસ એમાં આયા.
9 એપ્રિલ આનંદભાઈ વિદ્યાબેન પ્રકાશ 9 એપ્રિલ
બંને
બંને કે 30/21 46 87 નીતાબેન
હાજર નથી રહેતા.
9 એપ્રિલ નીતાબેન 9 એપ્રિલ સેશન 189 રાજેશ્વરી નીરજ
બાતમી બપોર પછી રાત.
સેશન 255
NBW ચાલુ રાખજો
ચાલો
અને ડીસીપી મારફતે.
સેશન 298 સોહેલ
આમાં ભાઈ પીપી આને NBW એક યુટીપી છે, બીજાનું NBW છે.
જોડાયેલું બે જ.
પેલાનું વકીલ નથી રોક્યા, લીગલમાં ત્યાં
લીગલમાં 3 ને 5 બંને તરફે અરજી આવી છે અને નિમણૂક કરવા માટે કરેલી છે બધું હાજર
તપાસ કરેલો અને જેનું NBW છે જામીનદારે નોટિસ કરી
છે બસ ગણાના જાવ આપણે એફિડેવિટ સાથે હાજર રહેવા માટે જાણ કરેલી છે. સેશન 298 397 398 સોહેલ સર એમાં
નહીં. આ બંને છે તો ખરા
બંને હાજર છે.
NBW
હા સર 298 397 છે તેનો લાસ્ટ ડેટ છે
મોહમ્મદ અકબર છે.
8 સર મેં પીએસઆઈ માટે હતું આ જઈ શકે એનો મુદત રિપોર્ટ આવે છે.
તેના માટે મદદ છે.
હવે
સાહેબ ઇન્વેસ્ટિગેશનમાં ક્યાંક રોકાયેલા છે. ભલે ને NBW કાઢો સાહેબ, બેલેબલ કાઢો ના હોય તો. રિપોર્ટમાં એવું લખ્યું છે કે ભાઈ હું તપાસના કામે રોકાયેલો છું,
નાના છે.
બહારગામ છે.
અત્યારે ક્યાં પોસ્ટેડ છે?
એ ફર્સ્ટ લાવો ને એક મિનિટ.
બસ
લીંબાડ
મુદત રૂપે ત્રીજો બે લેબલ વોરંટ અને ત્યાંના એસપી મારફતે.
બાય દેવી વકીલ માટે કોઈ હાજર
તો લખી નાખી વકીલ પ્રાઇવેટ રોકવાના છે. આવી જાય તો જોઈ લેજો. નેક્સ્ટ મુદતે રૂબરૂ બોલાવી જાઓ.
સેશન 189
જામીન લાયક વોરંટ હોય.
એ બચી જાય છે યોગી સારું અને એક પંચની બની
યુટીપી જેલમાં જશે એક પંચ યાદી આપણે ઇસ્યુ કરી દીધી.
5 મિનિટ રહે એમ.
રાહ જોઈ બાકી રાખીએ.
સેશન 291 આરોપી યુટીપી છે પેન કાર્ડ પાસે રજૂ કરવા માટે આપણે યાદી રજૂ કરી છે. હાલ મુદ્દામાં
કોપી આપવાની છે, પેન ડ્રાઈવ આપવાની છે આરોપીને.
હા હમણાં રિસીવ કરાવી.
સેશન 308 ત્રણ પંચો મળે છે તો હાજી
બચી ગયા છે.
પંચની સમજ રજૂ કરી કોઈ આયા સમજ રજૂ
બાકી રાખ યુટીપી છે.
એના પાસે છે 22 લગભગ
આપી પેલા પીપી નું બોલાવી.
But I'll be very brief. Uh,
ફાઇલ આપી.
First, I'll deal with the facts and then 3 judgments.
File આપજો ને મને.
બેસો, બેસો. નહીં, બેસો.
કરજો ને આનું, એ
First and foremost argument is, how does Amit Sharma gets the status of protected witness? The whole case must fall down. Even according to prosecution's case, I am not making any submission of my own. Prosecution case itself. All these consignments were facilitated by Amit Sharma as a partner of Raju Dubai. જેટલો બી સાહેબ જેટલા કન્સાઇનમેન્ટ આવ્યા એ બધા જ ના ડોક્યુમેન્ટેશન થી લઈને એને ટ્રકમાં અપલોડ કરાવવા સુધી entire functioning has been of only one person, and he is Amit Sharma. And he is now the key prosecution witness. You can do it, but you have to arraign him as an accused first, then go to the magistrate under 306 and get him as an approver, but can't be as a witness. The person, this is like this, Lord, clear analogy that X plans a murder of A and tells why to execute it and why executes it and why is the witness. तब आप अमित शर्मा नो रोल जोजो. Amit Sharma is the only person in India who acts foreign on behalf of Raju Dubai, who is absconding witness number 7. And it is alleged that all consignments, I go by their case, their arguments, that all consignments were sent through Raju Dubai to India, and all consignments were cleared by Amit Shah. Therefore, the whole case must fall down on this. An accused, a person who has to be the main accused, you can make him an approver, but not a witness. An approver has a set procedure. Approver doesn't, Lord, is not within the domain of the investigating agency. They can at best apply. After proper application of mind, the competent court will. Here, since it's NIA, it will be Your Honor who will grant him the status of an approver, but certainly not a witness. And this is a major flaw. Now, my second argument. Lord, my statement, which is at Annexure B, Volume 1, at D35, page number is 6, D35, 6 by 10. This will be very important. The consignment came through Rajesh Kandla. While the containers were on the way, Raju Dubai sent Amit Sharma. Raju Dubai had said that Amit Sharma is his partner in India. Now, what more you want? Apart from anything else, ignore this statement also. Please, my humble request to your honor is, please go through the statement of Amit Sharma.
Yes.
Amit Sharma nowhere, two things, implicates me, and secondly, his own statement shows that he was the handler at Mundra port. Not only Mundra port, all goods that came from Afghanistan via Iran were managed by Raju Dubai and he was his handler. How can you base your case? Howsoever, my lord, fearful atmosphere prosecution might have created under the guise by naming Pakistan and Afghanistan. As a court of law, court is only concerned with the papers. Seriousness sometimes are created, sometimes are, my lord, manufactured, whatever we call it. Nonetheless, this is the case of zero evidence. Once you rely on Amit Sharma. Amit Sharma is a prime accused after Raju and those people in Afghanistan. Without his aid, I am going by prosecution case. Nothing was possible to be landed and cleared. It is because of his assurance that he is going to get it cleared that these people ventured to send it. And today, your whole case, your foundation of the case is Amit Sharma. The second argument was that I was in touch with the custom officer at Kolkata who committed suicide. I don't know, my lord, from where this statement was made, in as much as nothing is on record to show. No statement, no circumstances. To show that I was in any way in touch with no, yes, my lord, his statement is also there. Ravindranath Datta, which is at PW 40. Nowhere. From where does this argument come? Looking at the whole record, we don't find, because we can't go beyond record. Even if privilege is claimed, it is between court and him. But to me, no privilege is also claimed to show that I was in touch with this custom officer. Secondly, my lord, very important and a utter and patent lie, cross misstatement was made that I was in touch with the original handlers in Afghanistan. I go by their own chart. I don't want to make any submission on my own. Their own chart, Annexure B, Volume 2, D76 to D127, at page D94. This was the chart relied upon. Nowhere worth the name, my lord, this chart suggests that I had any contact at any point of time with anybody concerned in this case other than Amit Sharma and Raju Dubai. And with Raju Dubai, I had earlier transactions also. Not with regard to this talc, including talc, perfumes, dates, and many other items. At this juncture, I would, my lord, humbly request your honor to see the entire record. In every statement, even qua those to whom they have given clearance, namely VK and Vyom, the goods were handled by Amit Sharma. So,
That point was argued.
no, not qua Vyom and
They are clean sheet.
I am not on clean sheet. That I am coming to it. Even not that. Even their goods fictitiously, they say that they have investigated, they are innocent. Well, we don't go into it for this moment at this point. I will come little later. Even those goods where they were in dark according to prosecution. VK and Vyom, they had no role to play. The goods were cleared by Amit Sharma. So he knows that VK and Vyom are innocent according to prosecution. Yet their fictitious bogus challans and bills were created, and those goods which came in the name of Vyom and VK were also cleared by Amit Sharma. The whole foundation is Amit Sharma, partner of Raju Dubai, and the whole case is based on this. Now, my lord, third point argued was that when my consignment was downloaded and was on its way to Delhi, I had 2 telephonic conversation with Raju Dubai. Bound to be, if they are my goods, sent by him as talc, which is actually talc and was actually talc. And what is the duration? 50 seconds between 2 calls. It's not in dispute that talc that I imported was through Raju Dubai. It's their case, it was not talc, but it was opium or something. Heroin. That we come to little later. But nonetheless, the duration of the call is 50 seconds. All told. And if I have imported the goods from him, goods have been received, they have been cleared, and after it being cleared, if they are on its way, will I not talk to my importer? And that 50 seconds conversation is made the basis and foundation. The fourth argument on which that the proprietorship concern of mine, of other person, but alleged to be mine, and that person is merely for the names, was opened on 22/9, while the packaging bill shows 12/8, a month and 7 days before that. Now, mine is a proprietorship, not mine, but since they say that it is mine, I am saying it is mine. Yes, they say that the other accused was my employee and it was opened in his name. That is their case. But this is a form of a private ownership which doesn't require registration. Your Honor are much more aware than me that a proprietorship concern can be sued in the name of proprietorship concern or the owner, and vice versa. Proprietorship can sue or its owner can sue. There is nothing like registration. So name and little early name might have been there, but might not have come in operation. Business was not their name, because this is not like partnership or a company that it comes into existence only on the day when it is registered. Here registration is not required. It is only when I open up, I can operate it without an office, I can operate it anyway. But when I do it on a regular basis, I come out with the name. Had it been a partnership concern or a company, prosecution's argument was valid. The other argument was Afghanistan. It is again argued that all these transactions were dispatched by the same person, wanted accused number 1. Maybe because he was operating via Iran through Raju, Dubai. I am only concerned with my consignment and whether it contained only talc or it had heroin mixed with it. He may have given it to 100 people. He may have given it to 1,000 people. He is one of the biggest importer and exporter from Afghanistan of talc and many other items. Simply because all the consignments which you have been able to locate were dispatched by WA1 can't be the basis of my involvement. Now, my lord, other argument was, I am only answering arguments because my arguments are over. In rejoinder, I don't wish to expand in as much as I have to confine it only to their arguments. The other argument was that huge quantity of talcum powder was found from a scrap dealer, which according to them was separated and segregated from heroin. But that is not forming part of the record. What did they do with that? Whether, suppose, my lord, it's talcum with the scrap dealer. Even then it will have some semblance of heroin in it. It's not possible to 100% bifurcate between the two. Why did they not do anything with those huge quantity of talcum which they found it with the scrap dealer? What has happened to that? Whether samples were drawn, whether it has been sent to laboratory, nothing. It's like a wild imagination that this talcum which is found from a scrap dealer must have been segregated from that. They even don't say that this is a talcum or a talc powder which is bifurcated from the contraband goods, which is bifurcated from heroin. Simply you find something at some place, you join it. You try to amalgamate it. You try to find a way out of it. But then what did you do with that huge quantity of talc powder which you found from the scrap dealer? Now, my lord, coming now to very interesting. They say that we have made thorough investigation and inquiry to give clean sheet to Vyom and VK. Now, statement of one Goldie who stands absolutely at par with Amit Sharma. If we see the role, Goldie stands at par with Amit Sharma. He is also given a clean sheet. Your investigation with respect can't be a money-making machine that you exonerate persons of your liking and then to make a show, try to connect here or there and rope in somebody. Goldie's own statement, Amit Sharma's own statement would show that they were the kingpin operating in India. Now, my lord, his statement makes a very interesting reading. Insofar as VK is concerned, VK gives a call to Goldie, the owner, namely Pian, શું નામ છે? Anil. Surname is Parake, Anil Parake. He gives a call to Goldie that some central government officers have come to my office and inquiring about it. That statement is very interesting. If I am innocent, if somebody comes to me, I will go to them and ask that, sir, why have you come? I will not give a call to a stranger. Please see this is very important. That some central government officers have come to me inquiring about some transactions. I will go to that officer of the central government, not to a nefarious person like Goldie, whose work is to smuggle the goods with managing with the officers at different ports according to his own statement. And then Goldie says that you go away, you go underground, you switch off of your mobile, and he does exactly the same. And our so-called expert agency gives clean cheat to VK. Why should he first of all contact Goldie, who is known smuggler, who is known facilitator, who is the one who clears the contrabands? So one thing is certain, that he knows Goldie, therefore he phoned him. Telephone record matches, Goldie advising. If somebody tells me that tu underground thai jana, phone band kar de, first thing I will ask is, why? What wrong I have done that I should switch off my mobile? I should go underground. He himself says that મેં સૂચના આપી, મેં સલાહ આપી, એ પ્રમાણે ફલાણી જગ્યાએ જતો રહ્યો, એને એનો મોબાઈલ બંધ કરી દીધો, and then I managed and got him back to his factory. Goldie's statement is at Annexure B, Volume 3, D128 to D150.
Yes.
On being asked, I state that when I got a call from Sri Anil, who is VK Enterprise, around 5:30 p.m. informing that some government department had reached his premises for search proceedings, I instructed Sri Anil not to go to his home and wait for some time to know actual reason about the search proceedings in the firm name Vyom Fashion. I'm sorry, it's not VK Vyom. On knowing that BRI has initiated such proceedings in connection to NDPS, I contacted so-and-so alias Raju through WhatsApp call and tried to know the whole matter. Sri Vityas Kosar alias Raju Bhai informed me that there is nothing to worry about and forwarded invoice, packing list, country of origin certificate in connection of import made by semi-processed talc stones by Vyom Fashion at Mundra Port, and also sent voice note not to tell his original name as Vitesh, but to inform officer his name as Sri Raju Bhai. Therefore, I forwarded his mobile to Sri Anil, to Sri so and so alias. I called Anil and inquired about his position and informed that he along with his brother is nearby Parvat Patia. I instructed him to switch off his mobile and wait for some time till he reaches Parvat Patia. Simultaneously, I forwarded documents to my cousin, brother Amrit Singh, to take out the prints of documents. Sri Amrit Singh further forwarded the same to his brother-in-law Harpreet Singh, that is me. Atla Bhattama, Mr. Anil is there and they are giving clean cheat. This can't be a money-making machine that those who grease your palm, you keep them out. Sab, a statement pachi, how do they give clean cheat to Vyom?
Yes.
This is your witness. And he has all the contacts. એ વ્યોમને રાજુ દુબઈનો નંબર પણ આપે છે. રાજુ દુબઈ સાથે વાત પણ કરે છે. Why should I talk if some DRI officer comes to my office? I will first thing I'll go to DRI office. Say I'll not contact some notorious person and then take a contact from Dubai and I will talk to that gentleman in Dubai and he will come to me to collect the papers of his consignment. How does he know me? Namely Vyom. He is in Surat, I am in Delhi. How do you give the clean cheat? The whole investigation is faulty. That is the reason. Similar is with VK. He is very much in no. You are just saying to the court that we have thoroughly investigated. Is extremely dangerous for the court to accept it. When everybody has imported the talc in the same manner, same fashion, same supplier, same middleman, to give clean cheat to two after this statement is extremely dangerous. Now, my lord, the last factual aspect. That these goods of which the samples were taken from the floor is after 10 months, which I have argued, I have something more to argue. That's why. I have something more to argue on that. Before that and after that, there have been consignment in the same premises. How do you come to a conclusion after 10 months when 1, 2, and 3 consignments were loaded and unloaded, that this is yours and none else? Had it been a single consignment, possibly there was some arguable case for prosecution. But there being no other consignment, there being 2 other consignments, it is extremely dangerous to take all 3 into your sweep. It can be of 1, it can be of 2. You just can't draw wild imagination. Your imagination may not run into riots so as to rope in anybody you like and give clearance to anybody you like. Now, my lord, I am coming to law. There are 3 Supreme Court judgments which takes the view, and this falls down on that you can't draw a sample in absence of magistrate. Any sample drawn in absence of magistrate is no sample drawn. And one judgment which I don't have, by afternoon my friend will put it, that when a law requires a particular thing to be done in a particular manner, it is either done in that manner and law recognizes no other method and manner. જસ્ટિસ કાદરીનું જજમેન્ટ હતું ને 2001 નું સ્ટેટ ઓફ કેરળા વાળું, એ કાઢો. જસ્ટિસ સૈયદ શાહ મોહમ્મદ કાદરી. Now, first have a look at 2016 3 SCC copy on side and come straight to para 16. Both, my lord, drawing a sample as well as disposal, we are not concerned with disposal. Please come to para 16. Subsection 3. Your Honor got it?
Yes.
Subsection 3 of section 52A requires that magistrates shall, as soon as may, be allow the application. This implies that no sooner the seizure is effected and contraband forwarded to the officer in charge of the police station or officer empowered, the officer concerned is in law duty bound to approach the magistrate. Mandate of the Supreme Court interpreting the section. For the purposes mentioned above, including grant of permission to draw representative samples in his presence, which samples will then be enlisted and the correctness of the list of samples so drawn certified by the magistrate. સાહેબ આનું કારણ એ છે કે જેટલા સ્ટ્રિક્ટ લો તમે બનાવો, જેટલો તમે લો બનાવીને બને એટલી સિટીઝન્સની કોમન લોની ઇન્ડિપેન્ડન્સ લઈ લેતા હો, તો લો ઇઝ equally conscious. Parliament enacts the law. Parliament in its wisdom has thought that we want to impose stringent conditions. We want to make enforcement of this law very strict. Then Parliament is equally conscious that this can be misused. Therefore, on one hand, it makes the law. On the other hand, it protects the citizen of any mischief or innocent involvement. And therefore, more stricter the law, more stricter are the conditions on which you will act. And slightest deviation is not countenanced by law. You have made provision under 37. You have made so many provisions. Different acts. But then Parliament in its wisdom says that no, we will not give them that freedom. We will involve a judicial officer who will act judiciously. And therefore this, please see, again, permit me to read again. The officer concerned is in law duty bound to approach the magistrate for the purposes mentioned above, including grant of permission to drop samples in his presence, which samples will then be enlisted and correctness of the list of samples so drawn certified by the magistrate. એના વગર સાહેબ sample draw કર્યું એટલે પૂરું થઈ ગયું. It's the whole case has to fall down. I have to be discharged. If the sample which is required to be drawn is not drawn as per the mandate of law, the judicial officer is kept away. He has not signed that. Matter ends, no further investigation. In other words, process of drawing sample has to be in presence and under supervision of the magistrate, and an entire exercise has to be certified by him to be correct. બસ સાહેબ એટલું બતાવી દે મેજિસ્ટ્રેટને ક્યાં ઇન્વોલ્વ કર્યા છે અને જો આજ ના હોય then it falls. Because I have a Supreme Court judgment which says that initially things like officer not competent to investigate has started the investigation, has registered an offense. Supreme Court says no, if foundation goes, everything goes. Para 17. The question of drawing samples at the time of seizure, which more often than not takes place in absence of magistrate, does not in the above scheme of things arise. This is so especially when according to 52A(4) of the Act, samples drawn and certified by the magistrate in compliance with subsection so and so above constitute primary evidence for the purpose of trial. Suffice it to say, there is no provision in the Act that mandates taking of samples at the time of seizure. That is perhaps why none of the states claim to be taking samples at the time of seizure. Be that as it may, conflict between that we are not concerned. 18 and 19, we are not concerned. They are acting on Government of India's GR or a statutory notifications. But very interestingly, third line in para 18, there is no gainsay that such a conflict shall have to be resolved in favor of the statute on the first principles of interpretation. So it's a Government of India's baby. They have chosen to go by a notification and not by the mandate of the Act. They suffer. Now, your second judgment is, this citation gets changed, but that is by the bench of Justice Bopana and Justice Sundaresh. આપ્યા નથી બધી copies? Copies આપી છે બધી. Come to para 9. In para 9, only para 16 is relevant. 17 and 18 are Mohanlal 1, which I read. પહેલું judgment વાંચું ને સાહેબ. They followed that principle. Para 16, subsection 3 of 52A require magistrates shall as soon as may be allow the application. This implies that no sooner the seizure is effected and contraband forwarded to the officer in charge of the police station or officer empowered, the officer concerned is in duty bound to approach the magistrate for the purpose of mentioned above, including grant of permission to draw. This is what my lord certified to be correct. Now para 6. In our view, the view taken by the High Court is unsustainable. In the trial, it was necessary for the prosecution to establish by cogent evidence that alleged quantities of charas and ganja were seized from the possession of the accused. The best evidence would have been the seized materials which ought to have been produced during the trial and marked as material objects. There is no explanation for this failure to produce them. Mere oral evidence as to fair features and production of Panchnama does not discharge the heavy burden which lies on the prosecution, particularly where offence is punishable with stringent sentence such as, and in this case we notice that Panchas have turned that, we may. There are 9 which is quoted. From the above proceeding, it is crystal clear that remaining sealed stuff was not disposed of by executive magistrate. The contraband stuff, as also samples sealed as usual, were handed over physically to the investigating officer. Also, the trial court in its judgment specifically passed instruction to preserve the seized property and record the case in safe custody, as also co-accused was absconding. The trial court more specifically instructed to put a note with red ink on the front page of the record for its safe custody. In such a situation, it assumes importance that there was nothing on record to show as to what happened to the remaining bulk quantity of contraband. The absence of proper explanation from prosecution significantly undermines its case and reduces the evidentiary value of the statements made by the witness. Omission on the part of prosecution to produce bulk, this was with regard to destruction, but the principle is the same. Cannot be, as it is not clear that on what authority it was done. Law requires that such an authority must flow from an order passed by the magistrate. On their perusal of the record, it is apparent that at no point of time any prayer had been made by the prosecution for destruction of the said opium or disposal thereof otherwise. The only course of action the prosecution should have resorted to is for its disposal is to obtain an order of the competent court of magistrate as envisaged. Sample draw करती वक्ते as well as destruction वक्ते. In both the cases, first was sample, this is destruction, and the third judgment is order. I'll not read para 15, 16, and 17. Here they only say Mohanlal, and having not done, very same paragraphs have been. So in my respectful submission, my lord. Citation bolo, year 2001. No. My lord, there is a judgment. Roy VD versus State of Kerala. (2000) volume 8 SCC, page 590, wherein they have said that if something was to be done at an initial stage, if not done, there is no point in continuing with the trial. We discharge. Here in this case, there it was a case of registration of FIR and investigation. Court said that incompetent officer has registered an FIR. He could not have even investigated. If that is bad, we quash that. In our case, the very basis of drawing the sample falls. If the basis foundation of drawing the sample falls, in my respectful submission, my lord, I should be discharged. सब आ जजमेंट ની કોપી હોય અને એક બીજું જજમેન્ટ કે when a law requires, આ તો directly on the point છે, the one which I gave the citation. ના એ નહીં, justice એ બીજું છે 91 ટેલર વર્સિસ ટેલર છે. સર બે જજમેન્ટ એક આ જે જજમેન્ટ મેં કહ્યું છે કે if the foundation is faulty, then there is no point in continuing. You can't argue that wait till the trial. These all points are available at that stage of trial. Supreme Court says no. And the second one is that when a law requires a particular thing to be done in a particular manner, it is either done in that manner or law recognizes no other. But that may not be necessary, because here word Supreme Court has thrice used the word shall, has to be. Therefore, when Supreme Court says has to be, it is not in that line, it falls. But still, for by way of abundant caution, two judgments I will place it by two. This today itself, one on narcotic itself, that if the initiation of prosecution is faulty, no point in continuing with that prosecution. That's how it says. Obliged.
Lord, if I may mention, Lord,
Yes, you also mention.
Can I?
for accused number 8, my Lord, rejoinder,
Yes,
by
you may.
the clock, my Lord, it's been 5 to 7 minutes, my Lord, by the clock.
હાઈકોર્ટનું મેટર ચાલે હાઈકોર્ટમાં મેટર ચાલે છે કોની હરપ્રીત સિંહની ના બધાને.
Okay. So you want to make submission on whose behalf?
My Lord, accused number 8, Subhan Aryan Parwa.
દિલ્હીના લોકો છે.
Oh, yes.
My Lord.
Now on what point you want to argue? Because you have made your argument.
Lord, I made my arguments, my Lord. The prosecution.
But I take your lordship.
Submitted to my lords, that the prosecution submitted before my lords that I was involved in Hawala transactions before one Angadia. There is the name written in his register, my Lord, and presumed, my Lord. And presumed that the transactions before the Angadia, my Lord, were proceeds of crime, my Lord.
Yes.
My Lord, my only submission here is, my Lord, as Supreme Court in Prasanna Kumar and other judgments also says that, my Lord, while deciding the discharge application, my Lord, the court cannot take the evidence on record as gospel truth, my Lord, and cannot be just a postmaster saying that, okay, whatever happened, whatever written in the charge sheet is a gospel truth. My Lord, why I'm saying this, I am not denying whatever they say, my Lord, because at this point of time, if I deny, I am going to trial. My only concern here is, my Lord, that the only evidence against me at present is a diary wherein one name is written Sobhan. So to the best of my understanding of law, my Lord, the prima facie offense can be, my Lord, I'm not conceding, but can be, my Lord, a PMLA offense. To connect me with section 29 and, my Lord, UAPA, section 18, they are saying, my Lord, the prosecution states, presumes, without any evidence whatsoever, says that the Anglia transactions are the proceeds of, my Lord, the contraband. It cannot be, my Lord. If at all there is a proceed of the contraband, my Lord, they have to connect me with some contraband, my Lord. My Lord, NDPS Act is a special act wherein the punishment is also decided because of the quantity, my Lord. Small quantity, intermediate quantity, and commercial quantity. So if there is no quantity, my Lord, then I cannot be punished for under the provisions of NDPS Act, my Lord. So what they presumed is that just because my name is with one person, Khalid, on presumption, I can be, my Lord, charged with section 29 NDPS Act, my Lord. This is one aspect of it, my Lord. I'm done with this aspect wherein I am not connected with Khalid Kua, NDPS Act, my Lord. I am not connected with, my Lord, Hawala operators, Kua, my Lord, NDPS. If at all I am connected with the Hawala operators, my Lord, that is a matter of trial again. But that cannot be at this time or at present, my Lord, because they filed charge sheets, supplementary charge sheet, second, third supplementary charge sheet. But they cannot say or presume after doing thorough investigation and filing charge sheet, my lord, that I am presuming just because our hawala operator or an angriya is common. And my lord, the second is, my lord, they showed, my lord, the photographs, my lord, saying that I am, my lord, ISIS supporter, or I am supporting so and so religious group, my lord. My lord, admittedly, undisputedly, I am a Muslim and Afghan national wherein Taliban is controlling, my lord. I posted it on my Facebook accounts, the flags which are there in Google, you download it, post it, my lord, to support the Afghanistan army. My lord, and also there is nothing which is recovered, my lord, from my Gmail, from my other accounts, my lord. The only thing which is recovered, my lord, is one photograph with a gun. My lord, admittedly, my brother is a film director. I participated in that film, my lord. It was spread across, my lord, the internet that 3 young boys have participated in a national-oriented film, my lord. That is why, out of curiosity, my lord, I posted it on Facebook. My lord, I can never see one terrorist is posting any photograph like this on his Facebook account, which is public, my lord. So only because of the Facebook account, my lord, which I posted some photograph, they charged me under, my lord, QAP. And, my lord, the prosecution completely failed, my lord, to connect me either with a terrorist organization or a group. My lord, they cannot connect me with any person whatsoever in the list of accused, which is detailed, my lord, of people involved in the NDPS Act, my lord. And, my lord, the third point herein is, my lord, the only evidence against me is my name written on some diary with some hawala operator, which is again a corroborative evidence, my lord. It has to end me with conviction, my lord. Because, my lord, while framing of charges or hearing me on charge, my lord, the court has to see whether the
પઠાણ સાહેબ શું છે?
જી સર,
પઠાણ સાહેબ ને
પઠાણ સાહેબ કે તો મારે ડિસ્ચાર્જ અરજી આપવી જોઈતી હતી. હું કહું, હવે તમે બોલો તો શું થશે? મને કે મારે આપવી જોઈતી. હું કહું, સર તમને કોણ રોકી શકે?
ફોર યોર ક્લાઇન્ટ.
One should make an effort, but not this.
એ જવાબ
જી સર, હા છે. છે એક જ મારી પાસે છે. મારી પાસે. ઓકે ના ના મારી મેં જોયું.
Can go through that affidavit.
I have gone.
You have got,
Yes.
but when we wait because we are
Okay.
already hearing on discharge
Okay.
application. બોલાઈ દઉં. શું નામ છે? કયા ગુનામાં છો? મોબાઈલ ચેન્જ નથી. તો કેમ ભાગતા ફરો છો? ભાગતા કેમ ફરો છો? વોરંટ નીકળે શું કરવાને? કેટલા કેસ થયા છે? આ એક જ છે. છે પોલીસ સામે કોઈ ફરિયાદ છે પકડ્યા પછી? લઈ લો. બીજા કોઈને છે કે? બીજા કોઈને રીમાં કહેવાનું નથી ને કઈ કોઈ?
હા એટલે અમારા રીમાં કહેવાનું આવશે સર એ અત્યારે ત્યાં હાઈકોર્ટમાં ચાલુ છે એટલે ત્યાં જ રોકાયેલા છે. મને કે ત્યાં 5 વાગ્યા સુધી હું આવીશ તો રિપ્લાય આપી દઈશ તો આપ સાહેબ.
No, it won't be possible today.
હા સર તો પછી
If
આપ
it is in first session, then it's okay.
જી સર તો
Second
આપ
session.
સાહેબને જેમ
પણ બાકીના કોઈ એડવોકેટ્સ ને
હા
કહેવાનું અધરવાઇઝ
બીજા કોઈ
હાઈકોર્ટમાં બેલ એપ્લિકેશન છે.
હા હા આ બધાનું ચાલુ જ છે અરવિંદ સિંહના બધા એટલે સર આ પેરેલલ ચાલે છે. હું એ જ કહેવાનો હતો કે ત્યાંથી અમારો ત્યાં આર્ગ્યુમેન્ટ હવે ચાલે છે. મોસ્ટ ઓફ પતિ પણ ગયા છે. ત્યાં નમૂદરી એડવોકેટ છે ત્યાંના તો એમને ક્વેશ્ચન પાછો રેઝ કર્યો છે અને એવું કહેવાય એવું નથી પણ સમથિંગ બેન્ચ કુદાવવા માટે પ્રયત્ન ચાલુ રહ્યા છે એટલે ત્યાં ડીલે કરવા માંગે છે અને અહીં આગળ હવે ચલાવવા આવું ચાલે. કારણ કે કોગ્ઝે સાહેબની ત્યાં ચાલુ ગઈ છે અને એક મેટર ચાલી ગઈ છે ને હવે ડીલે કરે છે કે આ ડોક્યુમેન્ટ નથી મળ્યા આ સ્ટેજે સર હાઈકોર્ટમાં.
તમારે આપવા જોઈએ કેમ નતા આપ્યા?
સર આપી દીધા ફરીથી આપ્યા. નંદુજી સાહેબ આપ સાહેબને ત્યાં હતા તો પણ ડોક્યુમેન્ટ આપ્યા હવે હાઈકોર્ટમાં રેઝ કરે પાછું. એટલે સર અમે તોય આપ્યા મેં કીધું એ કારણ કે ડીલે નથી કરવા માંગતા અમે કોગ્ઝે સાહેબને ત્યાં ઓર્ડર મળતો તો લઈ લેવા કારણ કે હવે બધું પતી ગયા પછી આ ચાલી રહ્યું છે એટલે અત્યારે અમે ત્યાં રોકાઈ ગયા છે એવું થયું. એટલે અમુક વસ્તુ થાય છે આવું.
અમને તો અહીંની ખબર હોય ત્યાંની
જી સર જી સર.
Back from life is in Eastern school.
Yes, yes, certainly. Connectivity is open.
My lord.
Yes.
He got that. My lord, my only point was this, the only evidence against me at this point of time is, my lord, the name which is written, my lord. There is a very good landmark case, my lord. My ex-senior, my lord, late Shri Ramjit Malani argued one case, my lord. L.K. Advani, my lord, versus Union of India. Wherein, my lord, he said that anyone and everyone can write a name, but it has to be corroborated, my lord, with the substantial evidence, my lord. Corroborative evidence is not nothing, my lord. And, my lord, the second last point is, my lord,
In
my
that,
lord,
so far as I recollect, in that case, there was a trial.
there was a trial, my lord. There was a trial. Absolutely right. Absolutely right. But it got cost.
So now if you want to rely, then you can rely.
No, no, my lord.
Even if,
It got caught. So even, my lord, candidly, if I may say, my lord, the inherent powers of the High Court under 482 are equivalent to, my lord, 227 under the CRPC, my lord. Because in caution and in, my lord, 227, both, my lord, are similar, wherein evidences are appreciated and is seen whether this trial, if at all went, my lord, or goes against me, whether that is the only point, my lord.
it would sound very nice.
And, my lord,
It would sound very nice to hear that power under section 482 are similar to the power under section 227 of the code by the sessions courts. It's-
because both, in
But,
both the cases, my lord,
No, no, the section 227 is very much clear that whether the court has to consider that evidence is sufficient for framing the charges or evidence is prima facie, there is a case for trial. So far as section
Please,
482 is concerned, it are the inherent powers of the High Court. And when there is no specific provision under the law, the Honorable High Court can exercise that power. Here we are exercising, the powers which is provided in the code itself. So there is a
Please,
vast
Lord,
difference. It
please,
sounds,
Lord, if I may supplement also, my lord, by reading, my lord, that 227 read with, my lord, the Katina of judgment passed by the Supreme Court, saying that if the Sessions Court
yes,
thinks,
if it court
Then-
finds that
then
there is
the-
no evidence, then they has to,
please, please, my lord.
yes.
And, my lord, the last point here is, my lord, with regard to the presumption created against me just because of some photographs, my lord. My lord, I wanted to share the screen, my lord. Those photographs only, my lord, I wanted to show, my lord. The very photographs in the chart sheet, my lord, if the host may allow me to share this.
અલાઉ કરવું પડશે તો એટલે ફોટોગ્રાફ જોવા કોર્ટ અલાઉ કરશે તો
Screen share કરવાનું.
स्क्रीन शेयर कीजिए, यहाँ से अलाउ करना डिसेबल but I'll, if at all there's an inconvenience, but that's fine.
Share screen पर.
Well done. Well done. If my lord may see, my lord, this is the photograph the prosecution is harping upon, my lord.
Yes.
it has to be read with this Afghan trio wants to usher in a change, a new crop of young filmmakers from Afghanistan are on a mission to promote rights, my lord. The extreme right one is my brother, my lord. The whole article is there, my lord. This is Sobhan, my lord. And I have been, my lord, in that film only, my lord. My client has also written, my lord, that he's Payman, Sobhan's brother, who is the director of the film, my lord. So the prosecution cannot cherry pick, find one photograph with a gun and say that, okay, he's a terrorist. He cannot be. And my lord, like I submitted earlier, that my lord, if a genuine terrorist is there, my lord, he won't post photographs, my lord. They believe in the work rather than my lord posting it in the public platform, my lord. And my lord, the other aspect is, my lord, with regard to my lord, me supporting a religious group which is anti-Taliban, my lord, wherein I was supporting the army, Afghan army, my lord, because why I am saying this, Lord? I am not an Indian national, and the prosecution cannot expect that I will be supporting any person who is good with India or anything like that, my lord. I am still a valid passport holder of Afghanistan, Lord. The only mistake I did was, my lord, I did act as an investigating agency while talking to someone, my lord, because XYZ people, my lord, move the population of the country of Delhi, XYZ people, whomsoever we meet, my lord, we don't do due diligence. I met Khalid undisputed, admittedly. He used to come to my gym, my lord. Just because I met him, that doesn't mean that I am also involved in the said crime, my lord. And the last but not the least, my lord, the only thing is, my lord, 429, for my lord, section 18 UAP Act, my lord, corroborative evidence cannot be, my lord, relied upon in the charge sheet. And last, my lord, that my lord is very well aware, my lord, that UAP Act, NDPS Act are such draconian provisions, my lord, wherein you can't get bail. You have to prove that you are not guilty under section 43(3) of UAP Act, my lord, and section 37 of NDPS Act. So for such draconian provisions, my lord,
Yes.
the scrutiny also has to be, my lord, that my lord, harsh. Because you are actually implicating a person under such draconian provisions. So the charge sheet or the investigation has to be, my lord, on the face of it, I have to be accused.
Yes.
My lord. And my lord is very well aware that I would waste much time of my lord with regard to, my lord, the powers under section 227 and the ingredients of section 17 of UAP Act. My lord, I don't want to. My lord has been hearing this for a while now, my lord. And my lord knows this by heart.
So now this will end.
I'm deeply obliged. I'm deeply obliged.
Yes.
I'm deeply obliged.
Yes. Now you may leave. Yes. હવે એની કોઈ છે એમાં? બાકી? નાનો? Okay.
ધનંજય શેખાવત કરી કોણ છે? મિસ્ટર ધનંજય શેખાવત કરશે કોણ?
Okay. તમને admit કરી? હા, કરેલ. Yes, Mr. Dhananjay, you also now want to add something?
Yes, my lords. My lords, I'm sure.
How much time are you going to take?
I will only take 5 minutes to listen a little to what Rohit actually prosecuted and yes. Now, my lords, the story of Ahmedabad is very, very simple. I am a
a Afghanistani passport holder. I come to India.
You are for Mohammed
medical
Khan
visa.
Akhlaqi.
Mohammed Khan Akhlaqi, yes, my lord.
So you are not going to repeat the arguments which you have already made.
No, no, my lord. I will really. This is not required.
Yes.
Before my lords. My lords, as per the prosecution, what is my role? Number one, my lord, my lord, that. Okay. Now, my lord, the prosecution says certain WhatsApp conversations with certain wanted accused. Now, my lord, these conversations are at this speed and cannot highlight any participation of my part. I am not a part of any work. I have nothing to do with the transport of the alleged goods, how they were received, how they were distributed, none of it. My role is negligence, not present at all. The second argument that the prosecution makes is that I was present at the Noida premises. Now, my lord, that is the best case they can build against me is my physical presence allegedly in a house where certain seizure had happened of certain products. When the other accused also accused number 911. Now, my lords, again, at best, there are cases that I was physically present there. As far as my active work is to be considered, in any of the activities, in the planning, in the WhatsApp groups, I am included. Beyond that, my lords, there is nothing against me. The only statement of against me that any witness is required is that doctor at the Max Hospitality Hospital at Saket who confirms that the customer receipt I have of my examination is true and accurate, and that I have visited the hospital and so on so. Which is also been my case since day one.
Yes.
Now, without circumstances, I was arrested from the airport. But from the time I have come to India, and medical
That you argue.
yes, please, I have not been actively involved. No, again, I was my presence at any of the spot was at the Noida flat. In my lords, I have again, as I submitted, I'll tell it up meeting, but it is not uncommon to know Afghani reside in a particular area in Nagpur. If I have interacted with Dr. 9 or so on, so forth, then even then, any participation that I have in illegal activities has not been proved. All we are relying on is false substantial evidence, nothing to correspond.
Yes. Anything more?
No, please, my lords, I'm deeply grateful.
You may leave now.
Please.
Some of you come અને તકે સંભળે અને VCP સંભળે લઈ જાય. નહીં.
May I?
Yes.
Please, my lord. My lord, initially the FIR was registered by the ATS on 15th of September 2022. and it was the FIR number 06 of 22 under section, my lord, 8C, 21C, 23C, 25, 29 of NDPS Act 1985, and thereafter the investigation has been taken up by the NIA. And another fresh FIR was registered on 20th of August 2023, almost after 1 year. And the registration number of that FIR was RC02 of 23 oblique NIA oblique Ahmedabad. And some more sections were added. Even the Act of UAPA was also added in that FIR. And thereafter, my lord, on 19th of October, the charge sheet was filed by the NIA, and supplementary charge sheet was also filed, and under section 8C, 21C, 23C, 25, 29 of NDPS Act, and under section 18, 38, 39, 40 of the UAPA Act, my lord. And under section 120 of the Indian Penal Code. So, my lord, I'll just read some relevant portion of that FIR which has been filed by the ATS earlier. That is start from page number 29, and I'll just start from the initial. मारी श्री सरकार तरफे फरियाद है कि मैं आई, पेज नंबर 29.
What is your role?
That's what, my lord. I just don't have any role, and this I was wrongly implicated. And as per the investigation, they says that I have come there to receive the contraband substance, whereas they don't have any evidence or corroborative evidence or substantial evidence to connect me with the presence of his brother. So therefore, it's required to read the some portion of the FIR. May I read my? મારી સરકાર ફરજ ઉપર હાજર હતા. કલાક 17 વાગે નાયબ પોલીસ અધિકારી શ્રી કે પટેલ નાઓને બાતમી હકીકત મળેલ કે પાકિસ્તાન કરાચીનો અબ્દુલ્લા નામનો ડ્રગ્સ માફિયા અલ તયાસા નામની પાકિસ્તાની ફિશિંગ બોટમાં કરાચી બંદરેથી કેટલાક ગેરકાયદેસર માદક પદાર્થ હિરોઈનનો જથ્થો ભરી તેના માણસો મારફતે જખૌ વેસ્ટ ભારતીય જળ સીમા 13/9/2022 ના રાત્રિના સમય દરમિયાન આવી તેઓની બોટ વાયરલેસની ચેનલ નંબર 73 ઉપર જુમ્મા કોલ સાઇનથી સંપર્ક કરી તેને તેની બોટમાં ડિલિવરી કરનાર છે. આ હીરોના જથ્થાની ડિલિવરી ભારતમાં રહેતા અબ્દુલ્લાના સાગરીતો અની ચીફ ઓલિયા એલાઇસ અની ચીફ નામનો નાઇજીરિયન નાગરિક કે જે હાલ અમૃતસર જેલમાં છે, તથા મેરાજ રહેમાની અબ્દુલ સત્તાર રહેવાસી વેસ્ટ દિલ્હી કે જે હાલ કપૂરથલા જેલમાં છે તેઓને મોકલનાર છે. અને આ હેરોઈનના જથ્થાની ડિલિવરી ચીફ મેરાજ રહેમાનીના પંજાબના સાગરીતો સરતાજ મલિક તથા જોગિંદર સિંહ ઉર્ફે જગ્ગી નામના માણસો ગુજરાતમાંથી મેળવી પંજાબ ખાતે લઈને જનાર છે. હિયર આઈ એમ ધ જોગિંદર સિંહ, ધ પ્રેઝન્ટ એપ્લિકેન્ટ. એલએસ જગ્ગી નામનો માણસ જે ગુજરાતમાંથી જે હકીકત તેઓશ્રીએ કોરા કાગળમાં લખી લઈ તેઓશ્રીને એટીએસ ગુપ્ત બાતમીના આધારે રજીસ્ટ્રેશન સદરી લેખિત એટીએસ. Now all the procedure is there. I am not going into the procedure. This is the only role. And my lord, then on page number 30, next page number 30, 16 line. કોસ્ટ ગાર્ડ બોટ નંબર C408 માં બેસી કલાક 1.5 વાગે જખૌ કોસ્ટ ગાર્ડ જેટીથી રવાના થયેલ અને પોઝિશન 23 DEG 2319 and 06 ઉપર બાતમી હકીકત વાળી પાકિસ્તાની બોટ અંગે વોચમાં રહ્યા. દરમિયાન 14/9/2022 ના કલાક 30 વાગે કોસ્ટગાર્ડની બોટની ચેનલ નંબર 73 ઉપર એક ઇસમ હિન્દીમાં વારંવાર જુમ્મા મેં મુબારક બોલતા હું તેમ બોલતો હતો, જેથી રડારમાં જોતા નજીકમાં એક શંકાસ્પદ બોટ જણાતા તેની નજીક જઈ તેની ઉપર લાઇટ ફેંકી લાઉડસ્પીકરથી તેઓએ ये इंडियन कोस्ट गार्ड है रुक जाओ એમ કહેતા તે શંકાસ્પદ બોટ પાકિસ્તાનના દરિયા પર પૂર ઝડપે ભાગવા લાગે, જેને વારંવાર ચેતવણી આપી તે બોટને કોસ્ટગાર્ડની બોટ દ્વારા કલાક 1:25 વાગે પોઝિશન so ખાતે આંતરી રોકી લીધેલ અને કોસ્ટગાર્ડની બોટમાંથી સહાયક એન્જિનિયર શ્રી so તેઓની પૂછપરછ કરી બોટમાં 6 પાકિસ્તાનીઓ પૈકી 5 પાકિસ્તાનીઓ તથા તે બોટમાં મળી આવેલ 3 મીડિયાના શંકાસ્પદ પદાર્થ ભરેલ થેલાઓ કોસ્ટગાર્ડની બોટમાં ચડાવી તે 5 પાકિસ્તાની નાગરિકો તેઓની બોટમાંથી મળી આવેલ થયેલા 3 નંગને આસિસ્ટન્ટ કમાન્ડર thereafter, again, there is the procedure. Shankar ત્રણે થેલાઓ પોતાની કસ્ટડીમાં લીધેલ. They are the procedure. Now, again, I'll come to the last page of the FIR, where again my role is been assigned. Page number 43, my lord.
43.
Yes, ma'am. This is the last page of the FIR. જેથી ઉપરોક્ત પાકિસ્તાની નાગરિકો so and so ફિશિંગ બોટ્સ અલ તયાસામાં પાકિસ્તાની બલુચિસ્તાનના પછની દરિયા કિનારેથી વગર પાસ પરમિટે ગેરકાયદેસર માદક પદાર્થ હિરોઈન 38 કિલો 994 ગ્રામનો વાણિજ્ય જથ્થો 194 કરોડ 97 lakhsનો રાખી જખૌના દરિયામાં પોઝિશન so and so ભારતીય જળસીમામાંથી પકડાઈ ગયેલ હોય. મારી ઉપરોક્ત તમામ તથા આ હીરોનો જથ્થો મોકલનાર પાકિસ્તાની નાગરિક અબ્દુલ્લા તથા બોટના માલિક જમીલ અહેમદ તથા હીરોનો જથ્થો આપનાર અબ્દુલ્લાના 4 માણસો so and so. Then fourth line, તેઓના હેરોઈનના જથ્થાની ડિલિવરી લેવા આવનાર પંજાબના સરતાજ મલિક તથા જગીન્દર સિંહ પ્રેઝન્ટ એપ્લિકેન્ટ ઉર્ફે જગ્ગી તથા તપાસમાં મળી આવેલ તે તમામ વિરુદ્ધ મારી NDPS એક્ટ કલમ હેઠળ so and so મુજબ ફરિયાદ છે. So this is all the FIR filed by the ATS, my lord. And thereafter, my lord, like I'll just the facts has been clear from this FIR itself. I would not go into the details of the fact, but the thing is like they have got the information. બાતમી તેમને મળી અને બાતમીના આધારે they went to the coastal area and then they have landed up to the in between the sea and the ocean, and then they intercepted one boat. Malad, this is very important to note that they have intercepted only one boat who has come from the Pakistan and with the contraband substance. But they have not seen or intercepted, or just they have don't know why and how. They have not seen any boat who has come from the India side. One boat comes from the Pakistan side, but nobody comes from the India side. So where this 3 kilo like this substance was going to be dumped, where they are going to deliver, they says that present applicant means me. I was there to take the delivery. For that also they have not have any corroborative evidence that how I will reach to them. This is nowhere in the whole FIR has been stated, my lord. So this is the facts of the case. Now I'll come to my grounds, my lord. Now, my lord, there is my ground number D. On 15th, I was arrested. And on 12th of September 2022, the secret information was received by Officer K.K. Patel, Deputy Superintendent of Police. And on the basis of that information, I'll just draw that page 77 is the secret information which has been there in my compilation. Page number 77. આજ રોજ તારીખ 12/9/2022 કલાક 17 વાગે અમોને અમારા ખાનગી વિશ્વાસુ બાતમીદાર તરફથી હકીકત મળેલ છે કે પાકિસ્તાન કરાચીના અબ્દુલ્લા નામનો ડ્રગ્સ માફિયા અલ તયાસા નામની પાકિસ્તાની ફિશિંગ બોટ કરેલી કેટલાક ગેરકાયદેસર માદક પદાર્થ હિરોઈનનો જથ્થો ભરી તેના માણસો મારફતે જખૌ વેસ્ટમાં જળસીમામાં તારીખ 13/9/2022 રાત્રિના સમય દરમિયાન આવી તેઓની બોટ વાયરલેસથી ચેનલ 73 ઉપર ચુમ્મા કોલ સંપર્ક કરેલો અને તેની બોટ ડિલિવરી કરનારને હિરોઈનના જથ્થાના ડિલિવરી ભારતમાં રહેતા અબ્દુલ્લા સગરીતોને સાગરીત અનીસ ચીફ ઓલિયા ચીફ નામનો એન્જિનિયર નાગરિક નાઇજીરિયન નાગરિક જે હાલ અમૃતસર જેલમાં છે તેઓની મેરાજ રહેમાની અબ્દુલ સત્તાર અને વેસ્ટ દિલ્હી કે જે હાલ કપૂરથલા જેલમાં છે તેઓને મોકલનાર છે અને આ હીરોઈનના જથ્થાની ડિલિવરી ચીફ તથા મેરાજ રહેમાનીના પંજાબના સાગરીતો સરતાજ મલિક તથા જોગિંદર સિંહ ઉર્ફે જોગી નામના માણસો ગુજરાતમાંથી મેળવી પંજાબ લઈ જનારા છે. So this is the Batmi, and in the Batmi, everything has been written, and as per the Batmi, everything was right also. But how come this Batmidar has not given the name of the person who is going to the ocean and who is going to taking the delivery from the Pakistani port? That is missing. in whole charge sheet that is missing. Everywhere they are just saying that Sartaj Malik and his brother, he is going to come from Punjab and then they are going to deliver. But how and where, that is missing from the whole charge sheet. Now, my lord, there is a under section page 78, my lord. As per the law, my lord, page 78, my annexure E. I'll read this notice. It's a kind of Samaj Patra, my lord. Page 78. May I? Who MS Trivedi, Police Inspector, ATS, Gujarat, Rajya, Ahmedabad. Athi Tamo Jaggi Singh, son of Virpal Singh, Jate Singh, Umar was 33, Revasi, so and so and so and so. મુજબના કામે 6 પાકિસ્તાની નાગરિકોના કબજાની પાકિસ્તાની બોર્ડ અલ તયાસામાંથી માદક પદાર્થ હેરોઇન 38 કિલો 994 ગ્રામનો વાણિજ્ય જથ્થો કિલો 194 કરોડ 97 lakhs નો મળી આવેલ છે અને આ હિરોઈનનો ડિલિવરી તમો લેવાના હતા, જેથી આ ગુનામાં તેમજ આજ રોજ 15/9/2022 ના કલાક 20:55 વાગે અટક કરવામાં આવેલ છે. અને તે બાબતે તમારી પત્ની પૂનમ સિંહ, વાઇફ ઓફ જગી સિંહ ને ફોન ઉપર જાણ કરે છે, તેની નોંધ લેશો. મીન્સ like they have given the notice, but from where they have been arrested, how they have been arrested, nothing has been given. Just this notice has been given to them that you are arrested, that's all. And where is this is as per the mandatory provision of the NDPS Act, my lord, they have to be arrested and then they have to be produced the magistrate before the magistrate, and that all the procedure they have not been done, which is required and mandatory provisions and required to be done. Now, my lord, I'll come to another point. That is my annexure, my ground E. G. Page number 6. As per charge sheet paper, except secret tip received by Mr. K.K. Patel, Deputy Inspector General Inspector General of Police, ATS, nowhere and no one has disclosed the name of present applicant. Even all those Pakistani accused who were arrested with contraband substance have also not disclosed the name of the present applicant and his brother. Moreover, the main accused, number 11, that is the Lawrence Bishnoi, has also not disclosed the name of the present applicant and his brother. Therefore, there is no oral or documentary evidence to connect the present taken on 24th 9, and that the time of staying on 8th of March 22 to 9th of one day only, 9th of March 22. That is very long day before the present incident. Incident has taken place in September, whereas this he stayed in a hotel in the March in 22. So that also doesn't reveal anything. Anyone can come and go and stay anywhere, being a citizen of India. So this is also doesn't relieve anything. Then there is another statement of another hotel person, Santosh Babar Patidar. He stays in the hotel on 6th, 11/9/22 to 11/9/22. So in that hotel statement also, nobody has revealed anything except the fact that yes, they have come and they have stayed and they have marked themselves in the register, themselves in the hotel register. This is the only thing. Nothing else has been stated in the things. So we cannot come out with any conclusion that while staying in the hotel, they have come here to commit the offense only or take the delivery only. So now my next point is that, my lord, there is a supplementary charge sheet which has to be taken into consideration. That is on page number 8 of page number 8, para number 16.9. Here that they have mentioned in their this present reply also. In that para number 16.9, I'll read. Investigation revealed that in furtherance of the conspiracy and in order to receive the drugs, accused Miraj Rahmani, who is the brother-in-law of the accused number 8, has transferred following amount in bank account number 3 to so and so of accused number 8 in Kotak Mahindra Bank, branch Palam, New Delhi, through UPI. Now they have shown me 4 entries. These 4 entries are related to 16th of June 2021, then 27th of June 2021, 14th of August 21, 28th of September 21. Amount is respectively 10,000, 2,500, 4,000, 219,000. So now I'll come take my lord to the point of this entries, which is in my compilation. See, my lord, page number 82, annexure I. 16/6/2021. Page number 82, sorry, my lord, page number 82, we can see the dates. There is no entry of 16/6/2021, 16/6/2021 of 10,000. Kindly see, my lord. Page number 82.
Yes.
And then the another month starts. Then the entry for 27 June 2021. Now 27 June 2021. June, no entry of that amount also, 2,500, no entry. Then third one is 14th August 2021. 14th August. Now 14th August, there is an entry. That is 14th August 2021, but that is in respect of we are the brother, like this Miraj, who is the accused number 10. He is my brother-in-law. Banevi che maro. So therefore, for about the entry number, which is not correct because the bank statement, no details of the above said date is attached to the in supplementary charge sheet. So, my lord, that is my brother-in-law, and it's quite obvious we can send the money to jail or he can get it. So, this is the I just give the answer to this, and thereafter, my lord, I have another. These are the four entries, and fourth entries, that is 28th of September 2021. That is also nowhere is showing the amount which they have said. So these all are the concocted and bogus entries, and they don't relate to with my accused, my applicants, my lord. And thereafter, my lord, I have a. Moreover, these entries are belong to the June 2021 to September 2021. And I earlier said that it's quite obvious that can be possible. And transacting little amount of money to a relative is cannot amount to a such kind of crime. Now, there is another point is that paragraph number 16.10. There is also number of entries they have shown. And regarding that entries, my submission is that it is alleged that the present applicant has sent money to accused number 10, namely Miraz Rahmani, who is the brother-in-law of the present applicant and lodged in the different jails in the state. However, the applicant stated submit that all the entries shown in the above said paragraphs are related to May 22 to September 22, and during this time, the present applicant has paid canteen bills. Kindly see, my lord. These are the very small amounts, and everywhere in those entries, my annexure J. I'll show you my annexure J. They all are specifically has been written that canteen bills have been paid by me. J. J. See, my lord, on 21st of May 2022, I paid 2,919 ₹8 80 paisa, and in that entry we can see my lord Kapurthala jail canteen Patiala. Can you, my lord, narration માં ત્યાં દેખાય છે સાહેબ. પછી 21/5/2022 માં પણ કપૂરથલા જેલમાં કેન્ટીન બિલના બીજા પૈસા ભર્યા છે ₹2,998. Then next page 87, 16/7/2022 માં અમૃતસર કેન્ટીન કપૂરથલા જેલ એમાં પણ ₹1,999 દેખાય છે સાહેબ. પછી આપણે આવીએ પેજ નંબર 88 ઉપર. ત્યાં 25/7/2022 અગેન અમૃતસર કેન્ટીન પટિયાલા 6,497 ની એન્ટ્રીઝ છે. પછી 28/7 આવ્યા. હવે અમે અહીંયા અમે અહીંયા બેસીને અમારા બનેવીને જો કેન્ટીન બિલ પે કર્યું હોય તો એમાં ક્યાંથી અમારું એલિગેશન આવી જાય છે કે અમે એનાથી રિલેટેડ છીએ. So this is the thing, and thereafter, my lord, as per the UCO Bank charge sheet, here kindly see the annexure K. Annexure K. This is the statement of the UCO Bank. Nowhere it has been stated that I have any transaction with the present accused person. Nowhere, no specifically they have mentioned even. But just to misguide the honorable court, my lord, they have just made up pages over pages. More than 200 pages they have made this kind of this charge sheet. But in the whole charge sheet, there is no role of mine. Thereafter, my lord, I'll just show you regarding the call details. I'll come to that. That is paragraph number 17.37, page number 26 of supplementary charge sheet. 17.3.
Yes.
No, 17.37. Page number 26. Allegation against, this is the technical evidence. Allegation against me is that call details records revealed that accused number 7 was using the mobile number so and so, and accused number 8, that is me, was using mobile number 2 mobile number, and there are 302 calls between them during the period from 29/8/2022 to 10/9/2022 for the commission of crime, which establishes that commission between the accused number 7 and accused number 8 for the commission of crime on the direction of accused number 9 and accused number 10, who lodged in Amritsar and Kapurthala jail respectively at the behest of accused Lawrence Bishnoi, accused number 11, who was also lodged in Tihar jail. So my respectful submission is that this is called details is related to 29/1/2022 10/9/2022. Obviously, they are the brothers, real brothers. And who bar them not to talk so many times? Is there any bar or is there any violation of talking to each other for so many times? And moreover, they have not talked 302 times. I'll just come to that point also. I'll just come to that point. See, my lord, first of all, they are the real brothers. They can talk many times, number of times. Nobody can stop them talking to each other. And moreover, such technical evidence given in the supplementary charge sheet is no use of implicating both the brothers with the present crime. However, no CDR, no SDR are submitted along with charge sheet papers. So what's the point of saying that 302 times they have called to each other? Without CDR, without SDR, so how can they connect me to the present crime, my lord? Therefore, it is a baseless allegation, and even after the whole trial, no fruitful result will come out regarding the present applicant. Now, my lord, another 17.39. That is another charge against me. It says that accused number 10, who is the brother-in-law of accused number 7 and 8, was using mobile number so-and-so from Kapurthala jail, communicated with the accused number 8, that is me, on his mobile number so-and-so, and there are 55 calls between them for the period of 24/6/2022 से 8/9/2022 સુધી for the commission of the crime. How do they know that this is for the commission of crime? I don't know. But which establishes that accused number 10, on the direction of accused Lawrence Bishnoi, accused number 11 has also roped in accused 8, who is the real brother of accused number 7, and gave them 8 to 7 tasks for receiving the narcotics drugs consignment from Jakhau at the behest of accused Lawrence Bishnoi. So, my lord, my respectful submission regarding this allegation is that first of all, there is no CDR, no SDR report which established that we have talked 55 times with my brother-in-law, that is accused number 10, who was in the jail. And we are wrongly implicated for the above said baseless case, and hence such technical evidence given in the supplementary charge sheet is no use of implicating the present applicant in this crime, my lord. Now, my lord, I have come to the page number 27, para number 17.40. Allegation against me is that accused number 10, who is my brother-in-law, was using mobile so-and-so for Kapurthala jail, and accused number 8 was using so-and-so, and there are 5 calls between them for the period from 31/7/2022 से 25/8/2022 for the commission of the crime. Now,
as far as full detail is concerned, you can simply say full details.
No CDR, no SDR. And there is no recording also. Nothing is there. So these are the, I just wanted to point out how they have implicated me without any reason. And then I'll just see. These are all the related to, and my lord, I have given all the bifurcation, all the details, everything. It may be taken care of while giving the judgment, my lord. So my case would be very clear cut. Then all these are further related to that. And now, my lord, again, I would say that is my submission number 17, that except Pakistani Al Tayasa fishing boat, there was an Indian Coast Guard. The boat which we have boarded, ATS team has boarded, that is boat number C408, and then Al Tayasa boat. There should have been one more boat which was supposed to receive the delivery of the contraband substance. The above said boat from the India side was not intercepted. But hawa ma avi ki vastu.
That you argued.
I have, that I was said in my facts, now it was in my ground, but I have argued. So, avi te na hoy sir. Koi to link hovo joiye, they should have a chain of link to connect with the crime, my lord, which has been missing. And by specifically saying to save some bigger fish, this small person has been implicated in this wrong case, my lord, by the ATS. Because someone should be there on the coastal side, in the India side, that who has come from the India side to receive the contraband substance. But those person who has come from the India side has not been disclosed by the ATS and by the NIA itself. And unnecessarily, they have implicated in this NDPS and then UAPA and such a become. So, my lord, my respectful submission is that my client is innocent person and he wrongly implicated in this case, and I may be given bail for this behalf, though there is a section 37 is 37 of the NDPS Act bar. But still, and section 43 of the UAPA also bar. But still, like I have pleaded my case beyond all the reasonable doubt that I may be given bail, my lord. And now, my lord, my humble there is a case of our Gujarat High Court. There is a judgment. May I just a relevant portion of that judgment I will allow to read.
Is it charge sheeted for UAPA? Is it charge sheeted for UAPA? Yes. After NIA?
जी
Initial charge sheet was filed by ATS.
ATS
There was no UAPA.
जी
Subsequently, it is.
जी subsequent
Yes.
My judgment copy આપી દીધી છે. એ તો ત્યાં તો આપી દીધી ને, આમની બાકી છે. આટ લઈ લેજો. Page number, paragraph number 3. Mr. Dholakia, learned advocate for the applicant, relied on the decision in the case of Bharat Chaudhary versus Union of India, reported in so-and-so, in support of his submission that in absence of any possession of contraband article and the printout of WhatsApp message downloaded from the mobile phone and devices seized from the mobile phone were not treated to be sufficient material to establish live link between the co-accused and the accused whose bail was under consideration before the Supreme Court, as scientific reports in respect of the said devices was still awaited. Now, my lord, paragraph number 5 is the findings. Next page. Having heard learned advocates for appearing parties, it emerges on record that the applicant is not found in possession of any contraband article. Over and above that, the call data records may reveal that in and around the time of incident, he was in contact with the co-accused who were found in possession of the contraband. Since there is no recording of conversation in between the accused, mere contacts with the co-accused who were found in possession cannot be treated to be a corroborative material in absence of substantive material found against the accused. Now, WhatsApp chat in between the co-accused shown to the court, there is hardly anything which connect the applicant with the present offense, or even asserting that he ordered for the same which were to be delivered by the accused found in possession of contraband. In absence of any other material which is still to be retrieved from the devices of the mobile phone and the information thereon, which is still awaited as considered by the Supreme Court in the case of Bharat Chaudhary, said material cannot be considered to be sufficient material to establish any live link with the co-accused who were found in possession of the contraband. So, Mala, this is my one judgment, and thereafter another judgment. Another judgment is he has quoted our Gujarat judgment. Punjab and Haryana High Court has quoted our judgment and given bail to the 3 accused person who were implicated in NDPS case. No, upon. Now, my third judgment is 1996. Ambalal Ranchod Thakur versus State of Gujarat. I'll just read the head notes only. Petitioner alleged virus under section 27, 37, 52 of NDP.
you are reading which judgment?
Third one is Ambalal Ranchod Thakur. I just given age. I'll just read the head notes, not take much of the time on this honorable court. Grant of bail, requirement to comply with mandatory provision of act. Petitioner contended that FIR does not reveal compliance to of any mandatory provision of the act. Petitioner contended that court should not wait till the completion of trial. Permissibility to grant bail to pre-trial stage, exercise the power to grant bail, condition proceed thereto. Whether section 37 is ultra virus, article 21, petitioner contended that the explanation to section 27 is in contravention of article 13, read with intended for personal consumption, presumption to be drawn against the accused under section 54. Constitutional validity of whether provision of section 50 ultra virus of NDPS Act rules requiring petition to be heard by division bench held. There is no substance in contention the pre-trial stage that there is non-compliance of section 21, 42 and 50. Court ought to have held that there are reasonable ground for believing that accused is not guilty of offense. Non-compliance of mandatory provision of the act cannot be inferred from the FIR. And now, my lord, my third judgment is on the article 21. Head note B, Constitution of India. Article 21, head note B. Article 21, Code of Criminal Procedure 1973, Section 437 and 439, accused of non-bailable offense can be released on bail, where prosecution has failed to establish prima facie case or can be released for reasons.
I've taken note of this.
Sure, sure. Okay, my lord. This is the last judgment. Now, my lord, my last submission is that there is no antecedents. There is no antecedents.
So far as your last judgment is concerned, I would point out that principle now has been changed recently by the
Please, my lord, that I know, but still,
the Supreme Court in this UAPA offense.
please, my lord, I know that, but still, like, just for the pencil of the court, I have just given it. It may not be considered afterwards, but still, my lord, I would say that I am not the person, like, I don't have any antecedents, and since. And there is one more point is there. They have said that somewhere in Jamnagar, I have got the delivery of 15 kilos of that. And for that also, it is just allegations. No FIR has been submitted against me anywhere. So this is all my respectful submissions are there. My lord, so my humble request is kindly grant the bail to my client, applicant. Highly obliged. Thank you.
આવતીકાલે આપણને અને એમને લોઅર કોર્ટમાં એક બેલ એપ્લિકેશન કરી છે એટીએસ જ્યારે ચાર્જશીટ કર્યું ને ત્યારે એમને બેલ ઓર્ડર નથી રજૂ કર્યો એટલે એ પણ મારે આપ નંબર
No, I'll show you from my pleading.
હા પ્લીડિંગમાં પણ રજૂ નથી કર્યો ઓર્ડર એટલે આપ સાહેબને સર
Even
એ
some
ઓર્ડર રજૂ
application was
કરીને
filed
પછી
before the High Court also.
હાઈકોર્ટ વાળું રજૂ કર્યું છે પણ લોઅર કોર્ટની અંદર એટીએસ એક
So why
900
do you want to rely upon lower court's order?
જી સર એમને એક ઓલરેડી રેગ્યુલર બેલ એપ્લિકેશન કરી હતી એટીએસ માં અને એ રિજેક્ટ થયેલી છે એ રજૂ નથી કરી એ પણ હું આપ સાહેબને ધ્યાન પર લાવી
But what difference it is going to make?
same subject matter, same allegation against the successive bail application has been filed. So, Your Honor, first off, he has to clearly submission that there is new ground for this bail application. There has to be a submission. So, sir, એ નથી આવ્યું એટલે આપ નામદાર સાહેબ એ લાવીને આપને
It is taken note of that. Earlier it was rejected by the NDPS court. It was by NDPS court at Bhuj.
My paragraph 3 સાહેબ મેં સ્પેસિફિકલી લખ્યું છે
Yes.
અને
સર,
કોઈ
બપોર પછી રાખો મારે થોડું જોવું પડે એવું છે અને આપ સાહેબ કહો તો કાલે આપો તો બપોરે આપ કહો. કારણ કે બપોરે વીકનેસ છે એટલા માટે આપ સાહેબ
સાહેબ આમાં હું એક વાત જરા એડ કરવા માંગુ છું મારી જે આ નિયા અંદર એડ થઈ એ પહેલા જ મેં હાઈકોર્ટમાં બેલ એપ્લિકેશન મૂકી દીધી હતી ત્યાર પછી નિયા એડ થઈ છે તો માય ફાઇલિંગ ઓફ માય બેલ એપ્લિકેશન વિચ આઈ હેવ મેન્શન હિયર ક્રિમિનલ મિસલેનિયસ 16729 of 23 that I have filed on 18/8/2023 અને નિયા એન્ટર થઈ છે 19/10/9 19/10 નિયા એન્ટર થઈ છે. તો મારી પહેલા દાખલ થઈ ગઈ હતી એટલા માટે હાઈકોર્ટે મારું ધ્યાન દોર્યું. therefore I had to withdraw that application and then I have filed this one. Highly obliged. લો.
ના પછી વધારે 14, 23, 25 બરોબર.
પછી આ બંનેનું ચાર્જશીટ ક્યારે ફાઇલ થયું અને કોણે કર્યું?
હા સર 4 થી 23/8/2023 8/5/2023
એ કોણે કર્યું?
ATS
આ બંને આરોપીનું ચાર્જશીટ
દ્વારા 23/8/23 ના રોજ કરવામાં આવ્યું. સ્પેશિયલ IDPS કોર્ટ ભુજ કચ્છ
એટીએસ એ ચાર્જશીટ ફાઇલ કર્યું
8/2023
23/8/23. એમાં આ બંને આરોપી આવી ગયા.
જી સર બંને આવી. જેનો મૂળ NIA સ્પેશિયલ કેસ નંબર પણ પડી ગયો છે સર.
એક મિનિટ. આ એનડીપીએસ સ્પેશિયલ કોર્ટ ભુજ ખાતે.
આ ભુજ ખાતે NIA સ્પેશિયલ.
હવે એનઆઈએ ને ઇન્વેસ્ટિગેશન ક્યારે આપ્યું?
29/8 હા
તમે ક્યારે ઇન્વેસ્ટિગેશન લીધું?
સર 29/8 ના રોજ અમે ટેક ઓવર કર્યું છે.
29/8/23 નો.
જી સર.
અને ઓર્ડર કઈ તારીખનો છે MHA નો?
19/8 નો સર.
19/8. તો ભાઈ ચાર્જશીટ કેમ એટીએસે કર્યું?
19/8
કારણ કે ખાલી એવચેનો ઓર્ડર અને પછી 20 તારીખે FIR લોન્ચ થઈ એના એમાં સર, ત્યારે આ ઓડીટી રિમાન્ડ ઉપર હતા એટીએસ પાસે સર. રિમાન્ડ નહીં સર, એના ઇન્વેસ્ટિગેશન ઉપર હતા અને એના દિવસો પૂર્ણ થતા હતા એટલે એને એ લોકોએ ચાર્જશીટ કર્યા સર. હજી કેસનો એન્ડિંગ ટેક એવો નથી કારણ કે આપણે એના એક થી બધું ત્યાં ઓર્ડર કરવાના બાકી હતા સર. પૂરો ઓર્ડર
પણ તમે ઇન્વેસ્ટિગેશન 29/8/23 ના
રાઈટ
કર્યું.
સર.
એનઆઈએ ની FIR કઈ તારીખની અને નંબર?
20/8.
એનઆઈએ RC 02/2023 એની તારીખ
20/8/2023.
20/8/23. આ બંનેનું પ્રોડક્શન ક્યારે લીધું?
NIA દ્વારા
અહીંયા પ્રોડક્શન કર્યું હશે ને તમે?
NIA દ્વારા
ખાલી 17 ચીફ હોવામાં
સર
ચીફ હોવામાં આપણે પ્રોડક્શન અમૃતસર જેલમાંથી આવ્યા સર.
પ્રોડક્શન વોરંટ ચીફ ઓબાના અમૃતસર ખાતે હતું. એનું પ્રોડક્શન વોરંટ થી લાવવામાં આવ્યું. 17/2/2023 ના રોજ આવ્યું.
ધીરે પાછળ મોકલે
મિરાજ ફ્રોમ ATS પ્રોડક્શન
ચીફ ઓબાના ને
17/2/23 ના રોજ પ્રોડક્શન વોરંટ ખાસ કરીને ત્યાં હાજર
17 જાન્યુઆરી
17 જાન્યુઆરી
17 જાન્યુઆરી 17 જાન્યુઆરી નું પ્રોડક્શન વોરંટ કે અહીંયા પ્રોડ્યુસ કર્યા?
અહીંયા પ્રોડ્યુસ થઈ ગયું
17/1/23 ના.
ચીફ ઓબન પેલા તો
અને મિરાજ રહેમાની ને
મિરાજ રહેમાની કપૂરથલાથી લાવેલો છે ATS દ્વારા. ત્યારથી પાલારા જેલ ભુજ ખાતે.
પાલારા ભુજ ખાતે છે.
જી સર.
Yes. Now beyond 30 days.
beyond 30 days. Section 43D. Two. Please,
અને તમને તમે પ્રોડક્શન વોરંટ ક્યારે માંગ્યું હતું? ચીફ ઓફ ગવર્નમેન્ટ.
10નો મહિનો. ચીફ ઉભાનો 10નો મહિનો.
અને તમને મળ્યું હતું ક્યારે?
10મા મહિના બાદ મળી.
10મા મહિના બાદ. પણ એમને કઈ કસ્ટડી લાગતા રીઝન
એની કઈ તારીખ છે ચીફ ઓફ ના પ્રોડક્શન ની?
17 રજૂ કર્યો ને
અરજી કરી હતી.
અરજી કરી 10મા મહિનાની કઈ તારીખ? અરજી કર્યા 20 અરજી કરી.
અને ક્યારે આપી હતી અરજી? ગ્રાન્ટ ક્યારે કરી હતી?
અરજી 21 ગ્રાન્ટ કરી.
Yes. Now first point, whether he can be now remanded to police custody, which now would be beyond 30 days.
Beyond 30 day matter, UAPA section 43D, subclause 2, subclause B, now provided. Provides એવું છે સર આપકો તો બી આપકો વાંચે after the provision the following provisions shall be inserted namely it provided further that if it is not possible to complete the investigation within the said period of 90 days the court may if it satisfied with the report of the public prosecutor indicating the progress of the investigation and the specific reason for the detention of the accused beyond the said period of 90 days extended the said period up to 180 days. હવે સર આ particular provision માં provided also that
એક જ મિનિટ. Yeah. The first provision છે એ ઇન્વેસ્ટિગેશન માટેનું છે.
હા એ investigation માટે હવે સર આ particular remand માં provided also that if the police officer making the investigation under this act request for the purpose of investigation for police custody from judicial custody of any person in judicial custody. He shall file an affidavit stating the reason for doing so and shall also explain the delay, if any, for the requesting such police custody. So, sir, આ આરોપી judicial custody માં છે અને આ judicial custody દરમિયાન with an affidavit. આ રિમાન્ડ બેલ એપ્લિકેશન આપ ફાઇલ કરી. એટલે સર the judgment of Honorable Supreme Court Gautam Navlakha. You are very well aware.
Yes.
The paragraph 129 of that judgment itself given.
Para 29.
जी सर. सर ये पैराग्राफ पर्टिकुलर ऑप्शन में ध्यान पर लाना.
Para 29.
128. सर पैराग्राफ 128.
Yes.
सर आप पहले ये पैराग्राफ को ध्यान पर लाओ.
Yes, yes.
उन्होंने शुरुआत सर फाइल से we would think that particular paragraph. We would think that the position.
Kyo paragraph? 128.
जी सर.
So to read 139, 140.
हाँ सर.
Kyo paragraph? 128 is something different.
सर 120 डिफरेंस है 140 का 149 से में आप
It is
शायद आप शायद ने आपको तो होगा एक पर्टिकुलर पैराग्राफ.
138. You can read from 138. 138 is the provision is referred.
हाँ सर. And in the specific words sir,
Yes.
beyond 30 days.
You can please read which paragraph you want to read.
सर हम कोई जजमेंट सर नाम जजमेंट क्या रहेगी मैटर चला हुआ. I'm sorry Your Honor.
Good.
और इसमें हमारे पास अच्छा नहीं. Paragraph 140. We would think that the position under section 167 as applicable in case under UPA is as follows. Undoubtedly, the period of 30 days is permissible by way of police custody. This court will proceed on the basis that the legislature is aware of the existing law when it brings the charges in the law. In other words, this court had laid down in Anupam Kulkarni Sutra inter alia that under section 167, which provides for 15 days as the maximum period of police custody, the custody of an accused the which provide Anupam Kulkarni Supra inter alia that under section 167, which provide for 15 days as the maximum period of police custody. The custody of an accused with the police can be given only during the first 15 days from date of from the date of the remand by the magistrate. Beyond 15 days, the remand can only be given in judicial custody. Ordinarily, since the period of 15 days has been increased to 30 days, the effect would be that in cases falling under UPA apply the principle declared in 1992 3 SCC 141. The investigation officer in a case under UPA can get police custody for a maximum period of 30 days, but it must be within the first 30 days of the remand. In this regard, the number of days alone increase for granting remand to police custody. The principle that it should be the first 30 days has not been altered in a case under UPA. As far as the second proviso in, second proviso absent. As per the second proviso in section 43D2B is concerned, it does bring about an alteration of the law. Anupam Kulkarni, sir. It is contemplated that a person who is remanded to judicial custody and NIA has not been given a police custody during the first 30 days. Sir, NIA has not been given police custody during the first 30 days. On reason being given and also on explaining the delay, court may grant police custody. The proviso bring about the change in the law to the extent that if a person is in a judicial custody on the basis of remand, then the reason given explaining the delay, it is open to the court to give police custody even beyond the 30 days from date of first remand. We may notice that section 49(2) of Prevention of Terrorism Act is paramaterial, which has been interpreted by this court in 2004 6 SCC 672. And the decision does not advance the case of appellant, though that was a case where a police custody was sought of a person in a judicial custody, but beyond 30 days. In this regard, we would appear that appellant had surrendered on facts of the case. On 14/4/2020, he was not in a judicial custody. He was produced with the remand report seeking police custody on 15/4/2020, treating this as a remand sought within the first 30 days. A remand is ordered for period of 7 days initially. There is no notice that an accused under UPA may be sent to judicial custody, police custody or granted bail if the argument that the police custody can be sought at any time and it is not limited to the cases where there is a judicial custody. It will go against the clear terms of the proviso and even the person who is bail out can after 30 days be remanded to police custody. This is untenable. Sir, આ કયું છે bail out થયેલો છે ને એના 30 days ના માટે છે.
If you read the sentence as a whole,
ના as a whole બી સર વાંચ્યું થોડું. if સર અહીંથી સર આ લખ્યું છે.
એટલે એની first argument છે
હા સર.
કે police custody can be sought at any time.
હા
અને માત્ર judicial custody માટે limited નથી.
હા સર.
કે આરોપી judicial
હા.
custody માં હોય તો જ લઈ શકાય.
હા સર.
એટલે see, this is the first, it is the argument.
હા સર.
Argument શું કરે છે કે police custody can be sought at any time.
હા
અને એની લિમિટ નથી કે માત્ર judicial, because section 43D2 second proviso read કે from judicial custody he can be remanded to police custody.
જી.
It does not refer to a case where a person is bailed out. Therefore this argument,
હા સર.
it cannot be limited for judicial custody only.
જી જી.
And it can be even granted if he is bailed out. Then the court records it will go against the clear terms of the proviso. And even a person who is bailed out
જી.
can after 30 days be remanded to police custody.
To police custody.
Now,
હવે this is
this is
untenable.
untenable, meaning thereby to say that this argument is untenable.
હા સર.
So what are you reading that is said to be untenable?
સર કયું untenable? પેલું જે બેલ આઉટ થયો છે એ બાબતનું untenable છે. હવે આપણા કેસમાં બેલ આઉટ વાળું સર એટલા માટે નથી લાગતું કે આમાં કોઈ બેલ આઉટ નથી તો એ untenable આ વસ્તુ લાગુ નથી પડતું એવું મારું સબમિશન છે આપના અંદર. કારણ કે એ બેલ આઉટ થયેલા વ્યક્તિના પોલીસ કસ્ટડી રિમાન્ડને બાબતે untenable કહે છે સર. Untenable, the case of appellant that the police custody granted on 15 was permissible and consists with his case does not appear to be correct.
This also I am not
Sir,
getting it.
સર આ કેસમાં સર મારું કેસનું સબમિશન એવું છે સર
No,
આપ
no.
તમને
See, if
આ
you read
કેસના
this
સબમિશન
paragraph,
જી સર
appellant surrendered on 14/4.
જી
He was produced with a report seeking police custody on 15/4/20.
જી
So on 15/4/20, a remand was prayed.
જી
Now treating this as a remand sought within the first 30 days,
જી
because he surrendered on 14/4 and remand was asked on 15/4.
જી
So to that extent, there cannot be dispute. Okay, on the next day, he was produced. And on the next day, he was, remand was asked, and 7 days remand was granted.
જી
So this is the fact.
જી
Now, if we read the last theorem, the court records that the case of the appellant that the police custody granted on 15/4/2020 was permissible and consistent with his case does not appear to be correct. On basis, on one hand, the first portion of the paragraph, he says that it was within 7 days of his arrest.
હા
Now, the last 3 lines, it records there. With his case does not appear to be correct, meaning thereby it is incorrect. Now, what is to be understood in this?
સર એવું કે છે સર અહીંથી વાંચો ફરીથી પેરેગ્રાફ 7 there is no sir અહીંથી વાંચો there is no dispute that the period was police custody. We may notice that an accused under UAPA may be sent to judicial custody. Police custody or granted bail. If the argument that the police custody can be sought at any time and it is not limited to cases where there is judicial custody, it will go against the clear term of the proviso and even a person who is bail out can after 30 days be remanded to police custody. I think full stop થઈ ગયો. This is untenable. The case is appellant. The case is
No, this
of
is
the appellant that the police custody granted on 15/4/20 was permissible and consistent with his case does not appear to be correct.
On the first three line, it says that police custody was within the first 30 days.
નહીં સર હવે સર
The contention is untenable, the argument.
સર હું આપને એક જ મિનિટ સર હું આપને હવે એ થોડી ક્લિયરિટી માટે હું આપને 3A દુષ્યંતભાઈ સરના 3A સર આજ સુપ્રીમ કોર્ટના જજમેન્ટના આધારે 3A માટે લખવામાં આવ્યું છે સર 3A આપ સાહેબ જોશો
That is the very same decision. Gautam Navlakha.
હા સર એની માટે એવું કહે છે કે બિયોન્ડ 30 ડે ના પોલીસ કસ્ટડી રિમાન્ડ માંગી શકાશે આ એક્સેપ્શન છે અને એટલા માટે સર આ પ્રોવિઝન નીચે સર અમે આપ સાહેબને ત્યારે પોલીસ કસ્ટડી રિમાન્ડ માંગીએ છીએ
If this is to be read as that it can be granted even beyond period of 30 days,
જી
then it means that you can ask for remand at any point of time.
નહીં સર વિધિન 30 ડેઝ નો 30 દિવસની અંદર જે 30 રિમાન્ડના પીરિયડ આપે છે એ એક્સરસાઇઝ કરી શકે છે પણ જે કેસની અંદર એવી જરૂરિયાત લાગે યુએપીએ માટે સ્પેસિફિક એવું અલ્ટરેશન કર્યું એક્સેપ્શન મૂક્યું કે જ્યાં એવું ઇન્વેસ્ટિગેશન એવું જરૂર કે આના વગર ઇન્વેસ્ટિગેશન શક્ય નથી આવા મહત્વના ચાર્જીસ વાળા કેસોની અંદર ડિલે એક્સપ્લેન કરતી એફિડેવિટ આપીને પોલીસ ઇન્વેસ્ટિગેશન ઓફિસર આ રિમાન્ડ માંગી શકે છે આ એઝ પર ધ પ્રોવિઝન
Yes.
जी सर तो पर्टिकुलर सर मैं यूएपीएस सेक्शन 43D 2B ના પ્રોવાઇઝો નીચેની આ એફિડેવિટ સાથેની રિમાન્ડ એપ્લિકેશન છે અને એ ગ્રાઉન્ડના આધારે સર કારણ કે સર આની અંદર એવું જ લખ્યું જ્યુડિશિયલ કસ્ટડીમાં the purpose of investigation for police custody from judicial custody of any person in judicial he shall file an affidavit stating the otherwise આ exception proviso લખવાની જરૂર નથી સર જો એને રાઈટ ન આપ્યો હતો beyond 30 day નો એટલે સર 30 ડે પછી આ પ્રોવાઇઝો લખ્યું છે એટલા પૂરતું સર એ બિયોન્ડ 30 ડે નો પ્રોવાઇઝો છે
See, the lawmakers are very much clear in
Ji.
their minds.
જી સર
They inserted the first proviso.
જી હા સર
The first proviso, they make it very clear
જી સર
that the period of investigation from 90 days,
જી જી
it is extended
જી
up to 180 days.
જી
So meaning thereby, you can ask for investigation up to 180 days.
જી સર
So there a time limit has been fixed.
જી સર ત્યારે સર એટલા માટે એ ટાઈમ લિમિટ થઈ ફિક્સ થઈ બંનેની બરાબર ફાઇલિંગ ઓફ ચાર્જશીટ ફોર પર્ટિક્યુલર રિમાન્ડ માટે 15 ના 30 કર્યા આ પ્રોવાઇઝો સાથે ક્લિયર આવ્યું પણ હવે આ પ્રોવાઇઝોનો પણ પ્રોવાઇઝો આવ્યો ધેટ મીન એક્સેપ્શન ઓફ 30 ડે ધેટ મીન સર હું એટલા માટે આપ સામે સબમિશન કરું કે પ્રોવાઇઝોનો પ્રોવાઇઝો આવ્યો ધેટ મીન્સ જે 30 દિવસના પીરિયડ એક્સટેન્ડ કર્યો જે CRPC ના 15 દિવસથી 30 દિવસ, એનો પણ આ પ્રોવાઇઝો આવે એટલે એ 30 દિવસનું પણ એક્સેપ્શન આ પ્રોવાઇઝોમાં આપીશું. એટલા માટે આ સબમિશન કરું. અને નવલખાના કેસની અંદર બી સર આ જ વસ્તુ કહેવાય. અને સર એટલા માટે આપ સાહેબને કહું કે જ્યારે લોની અંદર પ્રોવાઇઝો આવે છે ત્યારે એ એક્સેપ્શનમાં આવે છે. આ 30 ડે નું એક્સેપ્શન છે.
So first we have to read section 167.
જી જી જી
It
જી
says about 15 days.
જી સર
Given 15 days remand, no one can be remanded.
જી જી
Now,
એની અંદર કોઈ પ્રોવાઇઝો નથી લખ્યો સર. જી સર
now what change is brought from 15 days to 30 days?
30 ડેઝ ચેન્જ થયા.
That is for remand period. Police
Ji, sir.
custody.
જી સર
So there is no change if we consider the first aspect. There is no change in time. 15
Ji,
days
ji.
period is now extended up
Ji.
to 30 days.
જી જી 30 ડેઝ સુધીનો ચેન્જીસ આટલો જ થયો કે 15 ના 30 દિવસ થયા યુએપીએ માટે. પણ હવે 30 દિવસ થયા અને એના પછીનો પ્રોવાઇઝો મૂક્યો સર. તો
એના
સર
પછીનો proviso મૂક્યો first
હા સર
કે investigation 90 days નું હોય, so that is extended up to
180 ડેઝ
180 days.
180 ડેઝ.
See, I'm very much
જી જી સર
90 days, 60 days, 90 days,
જી સર
15 days, 30 days.
જી સર
So first condition as per section 43 D subclause 2,
હા
it pertains to section 167. So far as police custody's time period is concerned, it is extended, it is now from up to 15 days is now up to 30 days.
જી જી જી
90 days to 90 days, and 60 days is also extended up to 90 days.
જી સર
Thereafter, the proviso is inserted.
સર
First
ક્લિયર.
proviso,
હા સર Sir.
if it is not possible to complete the investigation within the period of 90 days,
જી તો એક્સટેન્શન 180 ડે નું આવશે.
court, the lawmakers have extended the period
જી
from 60 to 90, 90 to 90.
જી જી
The first what they did is that whenever there is 60 days, now you can construe as 90 days.
જી
Thereafter comes the first proviso. First proviso is very much clear.
જી
If you can't complete the investigation within period of 90 days,
જી
you will file an application
જી
for report
જી
with regard to progress of investigation and specific reason for detention of the accused beyond the period of 90 days.
જી
It is extended up to
180 days.
180 days.
જી
So the extension, period of detention of that accused even in judicial custody is now from 90 days to it is 180 days.
જી
So that you can file your charge sheet, XYZ, default bail, whatever.
જી
Because he cannot now claim, if you have asked for extension, and if that extension is granted, the accused would not be able to claim default bail on 110 days, on 100 days, or at 160 days.
જી જી સર એબ્સોલ્યુટલી રાઈટ યોર.
So that is up to 180 days, subject to that order is granted.
જી સર
Now this, then second, if making the first proviso,
જી
the lawmaker makes it everything clear,
જી
then why here it is not written in the second
સર એટલા
proviso?
માટે સર હા
Even it can be asked even after period beyond 90, beyond 30 days.
સર હવે સર જુઓ બીજા કશામાં અમેન્ડમેન્ટ નથી આવતું. પ્રોવાઇઝો સબ પ્રોવાઇઝોમાં માત્ર પોલીસ કસ્ટડી રિમાન્ડ માટે એક શબ્દ નાખે છે કે આરોપી જ્યુડિશિયલ કસ્ટડીમાં હોય એ દરમિયાનમાં જો રિમાન્ડ મેળવવાનો પ્રસંગ આવે તો ડિલે એક્સપ્લેન કરતી એફિડેવિટ ફાઇલ કરીને નામદાર કોર્ટને ત્યાં પોલીસ કસ્ટડી
That
રિમાન્ડ માંગી શકે.
application,
આ માત્ર જી સોરી
you are well within in your right
જી સર
when the application is preferred within 30 days, and secondly, that 30 days period is not getting over.
ના સર એવું નહીં સર ઇન્ટરપ્રિટેશન સર એ નહીં થાય. આ
That is
પ્રોવાઇઝો એટલા માટે મેં એટલે આપ સાહેબને એ સબમિશન કર્યું છે કે જ્યારે સ્પેસિફિક પ્રોવાઇઝો કરો કે વિધિન 30 ડે તો ફર્સ્ટ રિમાન્ડના વિધિન 30 ડે નો એનો એક્સેસ કરવો જોઈએ એઝ પર ધ લો એવું કહે છે. પણ એનો પણ એક પ્રોવાઇઝો આપ્યો કે સપોઝ એવું કઈ સરકમસ્ટન્સ ઉભા થાય સર આ જ કેસમાં આપ જોયું કે એના એવા સરકમસ્ટન્સ ઉભા થાય કે એનઆઈએ ને કસ્ટડી રિમાન્ડ નથી મળ્યા અત્યાર સુધીમાં.
So you mean to say, okay, let one agency has done anything,
ના
completed investigation.
યુએપીએ ની સેક્શન લાગી હોય તો સર હું આપને એટલે જ કીધું 43D2B સબ પ્રોવાઇઝોમાં આવતું હોય તો આપ નામદાર સાહેબ એ એક્સરસાઇઝ કરી શકો છો એઝ પર ધ યુએપી એક્ટ સેક્શન. આવું મારું કારણ કે સર અધરવાઇઝ સર કેમ સ્ટોપ થઈ ગયા છે આપ સાહેબ જો આખું સેક્શન કે સેક્શન 43D2 માં એવું સ્પેસિફિક લખ્યું છે કે CRPC માં આ છે હવે UAP માં આ ઇન્સર્ટ કરવામાં આવે છે પર્ટિક્યુલર 60 ડે 90 ડે અને 180 અને પેલા રિમાન્ડ માટેના 15 દિવસ એને એક્સટેન્ડ કરે અને એને આ એક્સટેન્ડ કરીને લખવામાં આવ્યું હવે એની અંદર બી સબ પ્રોવાઇઝો ધેટ મીન્સ જે ઇન્સર્ટ કર્યું એનો બી આ પ્રોવાઇઝો છે એટલે 30 ડે ની અંદર રિમાન્ડ માંગવા હોય તો આ યુઝ કરવાનો અને 30 ડે બિયોન્ડ 30 ડે આવતું તો પ્રોવાઇઝો નો અંદર આવશે આવું મારું નામદાર કોર્ટનું સબમિશન છે કે અધરવાઇઝ આ પ્રોવાઇઝો એની અંદર ના આવત જો આ ના આવ્યું હોય કારણ કે સર આ પ્રોવાઇઝો મીન્સ એક્સેપ્શન ઓફ ધેટ અબોવ પ્રોવિઝન પ્રોવાઇઝો મીન એક્સેપ્શન ઓફ અબોવ પ્રોવિઝન્સ કારણ કે સર આવું સ્પેસિફિક નથી લખ્યું વર્ડિંગ 30 દિવસ પછીનું પણ એક હોલ વર્ડિંગ લખ્યું કે ઇટ શુડ બી જ્યુડિશિયલ કસ્ટડી આટલા જ મિનિંગ ની અંદર આપ સાહેબ કહો છો એનો મિનિંગ લઈ લેવાનો કે એ બિયોન્ડ 30 ડેઝ હશે કે નહીં હશે
Take a case કે ATS initially ATS filed arrested one accused.
જી
He asked for remand.
જી
He was granted 5 days remand.
જી
During the investigation, now he is released on bail.
જી હા સર
After his release on bail, the investigation is handed over to NIA.
જી તો NIA જો એક્યુઝ ના રિમાન્ડ લેવા હશે તો એને બેલ કેન્સલેશન નો એપ્લિકેશન ફાઇલ કરવી પડશે ને બેલ કેન્સલ કરાવવા
I
પડશે
mean to say, until bail is cancelled, you want to carry out investigation?
હા સર
How can you do that?
સર એના બેલ કેન્સલ સર ઇન્વેસ્ટિગેશન તો
Suppose if-
કન્ટિન્યુ રહેશે
suppose-
એના પોલીસ કસ્ટડી માટે
Suppose if his bail is not cancelled, then your
તો સર
investigation,
જ્યુડિશિયલ કસ્ટડીમાં નહીં ગણાય
bail is not cancelled,
જી
then you want continue with the investigation?
સર ઓબ્વિયસ સર
Why?
સર
See, if investigation is transferred to you, NIA,
જી સર
and accused is on bail,
હા
then you are handicapped for
No, sir.
conducting the investigation?
ના સર એટલે જ મેં તો કહ્યું કે ઇન્વેસ્ટિગેશન કન્ટિન્યુ થશે એ બેલ આઉટ થયો તો પણ ઇન્વેસ્ટિગેશન સ્ટોપ નહીં થશે
Then you can continue with the investigation.
જી સર ઓબ્વિયસ સર પણ રિમાન્ડ મેળવવા હશે તો હું આપ સામે એ જ કહી રહ્યો છું દેર મસ્ટ એક્યુઝ મસ્ટ બી ઇન જ્યુડિશિયલ કસ્ટડી રિમાન્ડનો મિનિંગ જ એવું છે કે જે પ્રોડ્યુસ થયો છે એને પાછો લેવો છે રિમાન્ડનો મિનિંગ જ એ થાય છે એટલા માટે સર પોલીસ
So, if
કસ્ટડી
we
કે છે
accept your submission,
જી સર
then there are two contingencies. First, if he is in judicial custody, then you can say, pray for remand.
જી
If he is not in judicial custody, then you can't pray for remand.
ઓબ્વિયસ સર ઓબ્વિયસ
So now take another contingency.
જી
You have sufficient ground for seeking his remand.
જી
But if he is on bail, then you would become handicapped.
સર
That cannot be intention of any law.
સર જ્યુડિશિયલ કસ્ટડીમાં નથી ને
See, there might
The-
be a cases.
રિમાન્ડ માટેનો ફર્સ્ટ ક્રાઇટેરિયા જ આ છે જ્યુડિશિયલ કસ્ટડી એ 167 માં માટે પણ છે અને યુરોપિયન સેક્શન માટે પણ એ જ ક્રાઇટેરિયા ધેટ મસ્ટ બી ઇન જ્યુડિશિયલ કસ્ટડી સર
So I will ask to say one more contingency.
જી સર
If we accept your contention, okay, it can be granted beyond 30 days also.
જી
Now, there are many cases when your accused persons are behind the bar or they are in judicial custody
જી
for more than 1 year, 2 years.
જી
Meaning thereby you can ask for remand.
નો સર
Why?
there must be judicial custody of in this case
Yes,
there
yes.
must be in this
In
case
this case, we take the Mundra case.
જી
Their accused are behind the bar about 1 year.
જી
Now, many accused, you might not have availed the 30 days completely.
જી
So if we accept your contention, then you can now also ask for their remand.
yes your honor we can ask if accused is still in judicial custody જી સર એટલા જ માટે સર આ યુપી નું પ્રોવિઝન એટલા માટે કરવામાં આવ્યું કે સર જો એ પાવર્સ જ્યારે પણ ઇન્વેસ્ટિગેશન ઓફિસરને એવું જણાય આવે કે આના પોલીસ કસ્ટડી રિમાન્ડ મેળવવા જોઈએ તો સર એ બાય ફાઇલિંગ એને affidavit
You have any other order where there is granted.
આવતીકાલે રાખો હું સર એની લાઈન પર બીજું જજમેન્ટ
Okay. Basis on this, section 43D,
જી
and then here Gautam Naulakka,
જી
and on that basis, there are orders passed by the courts
જી
that it can be granted beyond 30 days. So that is the first rider for you.
જી
Second rider is the provision itself.
જી
You have to satisfy and reasons for delay.
जी
Second, this would be the first step, and then we can go for the second.
जी जी
Whether now in this, if it is permissible, then also can we grant you remand now at this stage or no?
जी
So first, we will have to satisfy on this aspect,
जी सर
and then second.
जी सर श्योर सर श्योर
And now I have gone through the section 43D2 also, Naulakha also.
जी
Apart from this, you will have to satisfy.
जी जी श्योर श्योर
And I don't want your general, Vijay Sheikh, any, only one. I would not expect the general grounds for remand. કે સર પેલી કસ્ટડી હતી ને માંગી લીધા છે ATS ને.
રજૂઆત કરી છે
Only on law point only.
લો પોઈન્ટ
The 43D, whether it can be granted, that would be first. Second, even if it is to be granted, do the remand application reveals the ground where it can be considered for police remand.
जी
So you are also facing the same 2 points.
ઓનલી લો પોઈન્ટ
Only low point, nothing else. First low point, both of you.
સર મોર્નિંગ માં રાખું છું કે બપોર પછી
ના, ના,
રાખું?
બપોર પછી.
બપોર પછી જી સર
કાલે કઈ સાક્ષી નથી ને તમારા? કાલે નથી લગભગ.
જોયું જ નથી મેં તો સર જોયું જ નથી
પેલી ક્યારે રાખી છે તમારી discharge વાળી? હા, 12 તારીખ બાકી છે ને.
હા સર બાકી આપણે રાખીશું